I just had a friend recently reach out because she has a special needs kid and she's terrified, keeps her up at night, worried about what happens when she and her husband passes away. So, Frankie, I'm so thankful that you're doing this with me today because I think a lot of people don't understand how they can protect their children. So, tell us a little bit about what is a special needs trust, and then we'll get into the details.
Well, a special needs trust is a discretionary trust designed to preserve eligibility for disabled beneficiaries receiving means tested government benefits like SSI and Medicaid. That's a whole lot of words to say. That's a formal definition. It is a trust designed to help people who are receiving benefits that are financially determined. So SSI, Medicaid are two of the most common. The asset limit is $2,000. So you can imagine if someone inherited $50,000 from a parent or a grandparent and can't have more than $2,000 in their name, this could cause a big problem in that person would be disqualified from their benefits for a period of time.
I am so glad that you brought that up because on my end, that is the number one way that I hear about special needs trust is someone calls completely freaking out because a grandma or an aunt has passed away and they've left what they thought was this inheritance to help this person out. And it actually causes them to lose all benefits and it devastates the family member. So that I'm just so thankful that you're doing this so we can go through it because you see that a lot on your end too, right?
Oh, yes. One thing I will add an anecdote here. Lots of people don't think of this from the aspect of, I had a child who was born without a disability and at age 35 was in a car accident and now has a traumatic brain injury and is receiving benefits. Mm-hmm. So I had a client who had an estate plan, married couple. The husband developed Alzheimer's and was no longer competent to sign new estate planning documents. Mm-hmm. And they had left a substantial amount of money in beneficiary designated accounts to a son who had a later in life disability. So then she had to hire me to do a guardianship for her husband so that we could change these forms through the capacity of the guardian and conservator role. So yeah, we can talk about some ways to deal with this. If you have children who aren't disabled, there's language we can put in documents to cover in the event somebody ever is. But yeah, that's something to think about. It's not just from birth.
I have already learned something because I thought I knew how special needs trust works and I had no idea that you could put it in just in case something happened. So that's huge.
Yeah, I call that the toggle provision is what I call it. That's not really a legal term of art, but there's language in the document that says, toggles on, says if someone is receiving means tested benefits, then at the trustee's discretion, the format and way that we distribute assets changes. There's a number of different ways to say it, but that's the language I include.
And is that something common that most attorneys put in, or is this something where you focus on this a lot? You know the importance of it.
I would say most attorneys who do what I do the way I do it, meaning this is my niche and this is what I do all day. Yes, if you're current on all the types of planning that are available in this day and age under the tax code, then yes, I figure most attorneys do that. However, most people think that when I end up litigating an estate, it's because there wasn't a will.
Yeah.
95% of the time, it was a will or a trust drafted by a non-trust and estate planning attorney. So I'm not trying to toot my own horn or line my own pockets. You can hire me, hire somebody else. Just make sure they know the ins and outs of trust planning and especially special needs trust planning.
Yeah, because not a lot of this isn't something a lot of people specialize in. A lot of people understand. So yeah, I think that's so important for anyone watching right now. I talk about this all the time, like make sure that you go to someone who specializes in these types of things. So I don't want to get like too much into the weeds about this for people that are watching, but there are different types of special needs trust, right?
Yes, and actually this is one time we might want to get in the weeds. This is pretty important. The terminology is essentially self-explanatory. If you have a special needs trust that is funded by someone, not the beneficiary, meaning not the person who is disabled, grandparent, parent, someone else in the family, or a combination of those people, that's a third-party trust because it's funded by third parties.
Got it.
First-party SNTs are funded by funds that are named to or owned by that person. So we see this a lot with lawsuit settlements.
Oh,
so
okay.
we will have an infant who is born and some malpractice during the prenatal phase or the delivery has caused a disability.
Okay.
There's a number of, I had a client once that her child had cerebral palsy. There are situations like that. That money from that lawsuit, because it is for the child, goes into a first party special needs trust. So we don't disqualify that child from the services they're receiving due to their disability during their childhood and later on.
Mm-hmm. That's really interesting. I guess now that's two things that you have taught me today that I had not really considered, because I always thought about third party trust, but I hadn't considered there would be first party also. So that makes sense. And
yeah, well, in the work you do, you probably wouldn't see a lot of first party trusts.
Yeah.
I draft a lot of first party trusts for plaintiffs' attorneys. Will hire me to help their clients do the trust planning. So in your line of work, you wouldn't see that very often.
Yeah.
But there is a other key difference between these two, and I think it's coming up on a future slide.
Okay, good. So, the evolution of third party. I'm interested in this too, because things come up because there's a need. That's the only reason laws exist. So explain to us the process, how this came.
Well, it's what we've been talking about this entire time. Actually, you had parents or grandparents that had assets and wanted to leave them.
Mm-hmm.
Let's say they had 3 children. They wanted to leave a third to their children. Well, before the evolution of special needs trusts, the parents didn't have much of a choice. They would have to disinherit that child or leave money to another child, hoping they would do the right thing. But there was no solid or really legal way to have that child inherit assets such as to not disqualify them.
So that's interesting, because with a lot of the clients that I work with today, so it's people retiring and they are planning for their children. And this is what I see a lot, where someone will say, make sure that this child does not receive anything. They can't be on beneficiaries because they'll lose their benefits. And then everything is placed on one child, hoping that they do the right thing, because they don't know that this even exists to do this.
Right.
Yeah. So, okay. So they were developed. Tell us a little bit about the laws about how this.
Well, that was touching on third-party special needs trust.
Oh, okay.
So this is now about first-party special needs trust. And this is true. And it wasn't really a safe and successful sail right through of getting this legislation adopted. Before 1993, it was unclear whether special needs trusts, in any form really, would be countable assets for Medicaid and SSI eligibility. And there were some revenue opinions issued, some litigation about this. So there was legislation in the 90s, 93, I see you have here on the screen, and in 1996 that cleared this up in the IRS code and in federal code, saying that a first party special needs trust is allowed. However, and this is a drafting issue that if you don't go to an attorney that knows what they're doing, this can cause huge problems. Okay. A first party special needs trust, to be part of the safe harbor regulations and rules, has to include the language that any leftover funds at the time of the beneficiary's death are to be paid back to Medicaid to the extent Medicaid has paid for care for that beneficiary. And then I always include in the document, and if there's any left after that, then to brother and sister, or then to somebody else in the family. Because sometimes, believe it or not, you do have money left over. Not often, but sometimes you do.
Surprising. Okay.
So if you don't have that language in the document, you've missed the safe harbor, and the IRS and SSI/Medicaid can count that trust as a countable asset. You get the other problem, though, where there's an attorney that doesn't do this, that picks up what they think is a special needs trust template that has that language in it and puts it in a document for a third-party trust. Third-party trusts do not have the Medicaid payback requirement. But if you put that language in a trust document for a third-party trust, you can cause other problems. So it's a very easy way to commit a malpractice when because some attorneys might not know what they don't know. So that's a very crucial step.
Yeah, that is really interesting because, again, I've seen people, I can see the economic argument because of like, why are they on Medicaid when they have all this money? But they don't understand the cost that's included in that. So I'm sure we'll get into that a little bit more.
I think so.
The requirements for this, because not everyone, I can't tell you how many people and I'm sure you get the same thing. They're like, well, they're not going to be able to work, so they need special needs. And it's like, no, it's not just about working. It has to be, my cat decided to join. I don't know if you saw, I was trying to push him off, but he's like, no, I'm getting in on this. So what are the requirements in order to get the first party?
Well, we just talked about number 3. Number 2 is, and I've mentioned already, court cases. So sometimes these are ordered by a court, or, if there's not a court involvement, if someone just, as I mentioned earlier, gets a traumatic brain injury at age 35, then the legal guardian or parent or whoever may be involved can work with an attorney to get the trust set up. Okay. And first party SNTs, this is important, and some people don't know this either. You have to be 65 or younger to be as a beneficiary. Yes.
Huh. Okay. So go into a little bit more about the safe harbor and what that means.
So, I've gotten ahead of myself on all this. This is what I just talked about. So,
we can skip over this if you want.
Well, really, it comes down to the example I just gave: court approved, SNTs or non-court approved, and the court approved are usually in personal injury cases, and the non-court approved are someone with a disability who ends up inheriting money, winning the lottery, and any way you might come into funds.
Okay.
Then I see you have on this slide, and I'll mention it, although it's not very common, pooled special needs trusts. And those are managed by nonprofit entities who do nothing but manage the investment and reinvestment of the assets and make the distributions. And of course, according to guidelines and provisions and the SSI rules. So if you have a special needs trust, it's a very small amount of money. Let's say maybe $30,000. Okay. This would be, if you don't have another trustee who can serve, this would be a good situation for someone that doesn't have a very large trust corpus. And pooled SNTs can be used for people over 65.
Okay. I'm not sure if we are even getting to this yet, or I can't even remember if this is in the slides, but maybe we can back up just a minute and talk about what is a special needs trust used for?
That's an excellent question, Tabitha. Well, you've included some of my accolades here on the slide, and I appreciate that. I have been doing this work exclusively for 12 years now, which came about because my father went into a coma and then had a permanent disability. And so I learned about this work trial by fire, and that's why I care so much about it. I know what it's like to have to manage a situation like that for a loved one, and I changed my practice focus to do this.
Okay. Yeah. And I think that's something often, that's when you find the people who are the best at these topics, because it's hit them personally. They know how confusing the process is, how complicated it is, and you know that emotional burden and want to make it easier for other people.
Yes.
Yeah. So your phone number is on here if people want to contact you to book an appointment with you. And we're going to come back to this again a little bit later. But who qualifies for it, why they want a special needs trust? Like, what are the benefits of it?
Well, SSI is one of the main programs the federal government provides, and there's a state component to some of these federal programs as well. This provides essentially what it says: supplemental income to those who are permanently disabled and blind, and or if you are under a certain income threshold over 65.
Yep. So we have a lot of people not a lot, but we do have people who, are transitioning with me, going on to Medicare and retirement, and SSI is their only income that they have coming in.
Yes, there are a lot of people in that category.
And, in order to qualify for SSI, you have to barely be scraping it by income wise.
Yes, that is true.
Yeah. So $2,000 resource limit. The home is excluded from that. They don't have to worry about the home, and 1 car exclusion. So there is not a lot of financial money that's involved in that. So Medicaid for this, SSI and Medicaid sometimes go together. They don't always go together. So you can have Medicaid and SSI, but you can also have just Medicaid and not qualify for SSI. So for the Medicaid, in both situations, you can't have more than $2,000 cash build up. SSI is going to be your income component into that. And then for Medicaid, that's the health insurance part to that. Although the Medicaid can expand a little bit slightly beyond just basic health insurance, but that's the big thing between the two of those, right? SSI is going to be your income, Medicaid is going to be your health insurance. And if someone passes away and leaves someone behind who is on SSI or on Medicaid, and they get an inheritance that is more than that $2,000, they're going to lose their health insurance and their income.
Yes, until there's a spend down. So in other words, that person is not going to get a lot of benefit from that inheritance. They're going to spend it down to become eligible for their benefits again, which if you're missing your Medicaid, I mean, that's, you can pay your rent with your inheritance. If you had to shell out everything you need out of pocket for your health care, that can be catastrophic loss of amount of money, depending on, Lord forbid, you had an accident during that period of time. So that could have grave results for somebody.
Yeah. I mean, I think sometimes people don't understand. They'll be like, oh, well, here's this small inheritance, but that small inheritance, if you're living in a facility that is covering your care, that small inheritance could end up costing them, some of these facilities are $17,000, $18,000 a month.
Well, correct, because it's not as if the minute you've spent all your inheritance, you snap your fingers and those benefits are back in place. Right. There's a lot of red tape that goes into getting that reinstated.
Yeah. I just think, obviously people have such good intentions. They want to help out a family member. It's someone that they love, but if they're going to pass that money on, they need to do it the legal way that protects the money to help the client. Security versus SSI, we both work with this a lot. For anyone watching, the biggest difference between this is Social Security is going to be your income that comes in based off of your earning record. So this is, you pay into this every year as you work. SSI is considered more of, I don't want to say welfare payment because that's not the right term. Is it?
Well,
right
I think that's how most people would understand it.
Yeah. So that's more, maybe you've been labeled as disabled, or maybe you worked, but you didn't work enough hours to get your full Social Security check in. So this is money that's going to support you with income.
This is something I get all the time. So I will have people call here that want to hire me to draft a trust or special needs trust. And I ask these questions. Do you have any beneficiaries that are on means tested benefits? And the person will say they get Social Security. And then I have to say, what kind? So SSI, as you're saying, are payments for people who are disabled, elderly, or financially destitute. I hate to use that word. The other program is commonly known as SSDI. And you're right. Those are people who have work history, and they are usually getting payments based on the quarters and years they have worked. through what they've paid into the federal systems, but that is not a means tested benefit.
Yeah, people it is really confusing because there are lots of different benefits that you can get in. Medicare coverage, to me, this is where we see the special needs that comes in a lot. So for us, what we'll see is, again, we'll be receiving benefits like SSI, Medicaid, things like that. And they'll be in what's called a dual plan. So they'll be on Medicaid and Medicare, both programs together. And that Medicaid coverage that goes with their Medicare covers their medication, covers their 20% with Medicare, covers their, if they're in a facility, covers all this extra care. And then if they lose that because they get an inheritance, they are suddenly responsible for having to pay that 20%, having to pay for their medications, and Medicare does not cover facility stays for long-term care. So they can lose their entire facility and be kicked out, or say pay $18,000 to live here. Again, these are people that are destitute already, and
Right.
we've just made it worse on them.
Well, and I'm glad you said that, because it is shocking to me how many people don't know that Medicare does not cover nursing home stays or long-term stays.
We get at least, I want to say, 5 phone calls a week saying, I don't know what to do. Mom was put into a facility and they're saying that we have to pay for this, but we have Medicare. Medicare doesn't cover that.
Right.
Yeah. If that's the biggest thing I could get across to people, I'm on a mission to get that across. So if someone is wanting to protect someone and get them in a trust, what rules do they need to follow for this?
Well, some of these rules apply to all trusts, but in general, on the issue we're talking about today, the first listed on the slide is control. So the beneficiary can have no power over the trust assets. Trust corpus, by the way, means the principal, the assets held in the trust. Okay. Trust income is the interest earned on those assets. So when I say trust corpus, and I've said that a few times, that means the money or assets in the trust. Okay. The beneficiary can have no control of that, is not to be able to just freely access that money themselves. There has to be a trustee who is administering the trust. At the time that most of your clients who come to me and my clients who come to me are going to want me to draft what we call a pour-over will with a revocable trust. Mm-hmm. So it's called pour-over because the will says, give my personal belongings to my spouse. Whatever is left goes to my trust. And then that trust document is the trustee's set of instructions for what to do with that money, who they can give it to, when, and for what, and when the trust is to terminate. So at the time that I draft estate plans in this manner and it's a revocable trust, it's that way for your life, for my client's life. At their death, it becomes irrevocable. And then, as you have here in slide number 2, the trust will be irrevocable, and it's not used for support. It's not used for food and shelter, clothing, that type of thing. These types of trusts are meant to be supplemental, not to supplant benefits, but to be supplemental. So things like a special vehicle. Someone needs a special vehicle to accommodate a motorized wheelchair.
Like a van.
Exactly, yeah. I used to be a trust administrator at a local bank, and so I got a lot of requests for things to finance through special needs trusts. Some kind of out there, but some a little, it might be a little weird, but it makes sense, like building a pool at someone's house. If that's the best way for that person to get movement and exercise, that's a okay expenditure. Maybe a laptop computer, maybe some classes or some trainings or something, some hobby the person enjoys. Anything that is supplemental is allowed to be paid for with the trust.
Can I ask a question here? I may be off, but so I get this question a lot and I never necessarily know how to answer it. So you're saying that the money that's in this trust can't be used for like for living situations and things like that. It's to basically enhance the quality of their life, right?
Yes, because if you use the trust funds for expenditures that aren't permitted, then that person will see a reduction in their benefits at a dollar to dollar match.
It's just
So if you, let's say you spend $250 from trust funds on something that is a non-permissible expenditure, your benefits can go down by that much. So there are penalties if you don't administer these trusts correctly, which is why naming a trustee in the document who is capable and an alternate trustee who is capable, and then a backstop provision if those two people aren't available that allows for a trustee who can handle these types of trust is absolutely imperative.
Do you have an example of what someone would purchase with the money that is not allowed? Like what is an example?
There are some utilities that could disqualify that.
Simple things that you wouldn't think about, right? Like
exactly.
You're like, well, this is a requirement for life.
Exactly. When I administered trust, we get requests for things that were so blatantly obvious it was not for the beneficiary.
Right.
If someone is disabled to the point that they need a motorized wheelchair and don't have use of their limbs, the side-by-side that you just asked me for is not for the benefit of that person.
That was not something that I was thinking would be asked for, but wow. Okay.
A sports car once. I'm like, I don't think that's really a necessary thing for someone, again, who's in a motorized wheelchair. This van that we paid for, that was good, but we will not be buying a Corvette with trust funds today or tomorrow either.
Okay, that makes sense. One more question over this one. Will you explain a little bit to you the difference between a revocable and an irrevocable trust?
It's exactly what it sounds like. Okay. A revocable trust can be terminated. You can put assets into the trust, put in title assets to the trust, title assets back out of the trust by yourself. It's your trust instrument, or the trustee can do that if you have a different trustee. Once a trust is irrevocable, it is irrevocable.
No changes.
You're not adding beneficiaries. You're not taking away beneficiaries. You can add funds, but you're not changing the rules and who is to get the trust money. Well, there are times you can do that. It is a judicial proceeding or a non-judicial proceeding if you meet certain criteria, but blanket statement, that's the definition of an irrevocable trust.
So talk about the ways that a special needs trust can be distributed.
This slide speaks as much to what you should do and also as much speaks to what you shouldn't do. So if you give cash, let's just say a beneficiary calls you and you're the trustee and says, I just spent $200 on fill in the blank. Actually, this would be an example for number 2.
Okay.
And you give that person the money, that counts as unearned income. Or if you just give the trustee money, or the beneficiary money, if you say, here's $200 for the week, that's going to cause a reduction in SSI benefits dollar for dollar. Which you give someone $200 and they're only getting $750 to start with, that can be a problem. Payments to third parties for things that are not in the, clothing, shelter, non-food category, that's not going to be detrimental to SSI.
Okay.
Food, clothing, or shelter expenditures, though, will reduce SSI, but not dollar for dollar. And if I had to tell you the formula off the top of my head right now, I absolutely could not.
But I think that number 4 is where so many people get mixed up with the trust because they think like, oh, it's their shelter or it's clothing, but there's just rules there. That's complicated.
Yes, they're very complicated. And something that I don't believe we get into today in this program, but ABLE accounts are a way to I don't want to say work around it. They're a great, I would say someone use in collaboration and together with an S&T.
So drafting third-party special needs trust. Tell us a little bit about this.
Okay, well, there are two basic types, an inter vivos or testamentary trust. Inter vivos means during life.
Okay.
So you create these trusts usually through their own separate standalone document. And this is a good situation if you have multiple family members who would like to fund the trust.
Mm-hmm.
This is the way to do it. A testamentary trust is formed at death. So good way to remember is last will and testament. A testamentary trust becomes active at the death of the, well, who we call the settlor.
Okay.
So we talked earlier about revocable and irrevocable trusts. Revocable trusts, as I said, offer a lot of flexibility. The documents can be amended, changed, terminated. You can move assets into the trust by titling them to the trust. You can remove them from the trust by titling them to back to yourself or others. And that's a wonderful way to set these up. But again, if you want multiple people who want to give to a beneficiary, a disabled beneficiary, and they don't want to each set up their own trust, the third party irrevocable trust is a good way to do that.
Okay.
And then we talked a little bit earlier about the importance of the trustee.
Mm-hmm.
So neither the beneficiary nor the beneficiary spouse can be the trustee. You're going to want a third party. And I am a huge proponent of corporate trustees and even nonprofit trustees, like in the pooled trust scenario we discussed earlier.
Mm-hmm.
The reason being, corporate trustees, such as local banks around here, United, Truist, Huntington, Citi, those are 4 I can name off the top of my head, have trust departments that do nothing but this. Mm-hmm. So they're skilled, they know the rules, they understand how to file the tax returns and any other reporting requirements. Mm-hmm. And corporate trustees are also held to a higher fiduciary standard than individuals. So you've got another layer of protection there. Large banks and trust companies are going to be insured for errors. Not that they are made frequently, but there's human condition involved. So if there is an error, they're held to a higher standard, and there's a greater assurance, I should say, that you'll be made whole because of the experience and the insurance involved with these entities.
And I want to back up here just a little bit too, because that's something that I have seen from trust is, number one, it's hard to find just an individual who's willing to take this on.
Yes.
Because if they don't do what is said to do, like legally, if they're legally held responsible for it, and that's a lot of pressure, right? Like if you do this wrong, the special needs person is going to lose their benefit, and you can get sued for doing it incorrectly, or there's probably other consequences. So I think it's really important for us to let people know there are entities out there that will administer the trust for them. You don't have to necessarily find an individual willing to do it.
Correct. Now, here's the next question I get. Is there a fee? Of course there's a fee. Mm-hmm. Banks and trust companies are in the business of doing this. They're not doing it as a charity. And as I just explained, they get exposed to a lot of liability administering technical trusts like this. So yes, there is a fee. It's based on a fee schedule, and every bank and trust company's schedules are different.
Yeah. What are some of the consequences if someone, like, let's just say an individual is trying to do it and they do it incorrectly? Other than, I guess we kind of already went over this, but I was just wondering if I missed anything on that.
Well, the biggest issue is you can inadvertently disqualify the beneficiary from some of their benefits. Now, there's a difference between clerical error or legitimate mistake and people fraudulently and wrongfully and willfully violating the trust document, which, as I said earlier, is the book of instructions for the trustee. Mm-hmm. So if we're talking an error on a tax return that can be fixed, that's one thing. Mm-hmm. If we're talking about you're helping yourself to the trust funds, well, then that's a crime and also a breach of the trust agreement, and you can face a lot of consequences.
All right. So tell us a little bit about this one here.
Well, we've hit on some of this, but Number two, we talked about how distributions are to supplement, not supplant public benefits. So we're paying for things that are beneficial and supplemental to the beneficiary, in addition to what the benefits they are receiving pay for.
Okay.
Discretionary, this I believe refers to language in the document that the trustee is allowed to distribute income and principal as they see fit.
Okay.
I don't too often in these types of documents nail down. I have many times given a laundry list of things that can be paid for. I don't do that so much anymore. I feel that the trustee is going to, hopefully, if we've picked a good one, understand what to distribute for. Number two, those rules and laws could change. So, I don't include language that we're complying with federal code, and the intent of this trust is to be a special needs trust as defined in the code. Benefit discretion. I'm glad this is on this slide. Your staff is good, Tabitha, because I don't know that I would have thought of this. The other reason I include the kind of broad language about distributions from income and principal is sometimes you are going to want to. Now, if you ask me to give you an example off the top of my head, I don't have one. I've not had this happen in my career. However, I do include language in my documents that say, and even though I just told you this is meant to be a special needs trust as defined in federal law, if the trustee thinks it's in the beneficiary's best interest to distribute money or assets that may disqualify the beneficiary, that's up to the trustee and their sole purview, because there could be a time that is in the beneficiary's best interest.
Okay. I like how a lot of what you're saying in there is like you're taking the situation, how it is today, with the understanding federal law may change. This may open up more new circumstances, may open up. So we don't want to necessarily base it off of today. We're following guidelines for today, but there's language in here for if the system evolves, it may be better to expand what's covered. So I like that.
Well, and I think good practitioners do that. We want to stay in the safe harbor lines. We want to play by the rules, but you also want to add language that lets the trustee off the leash if it's to the beneficiary's best benefit. The one I'll tell you, I can think of a circumstance that might make sense.
Okay.
Let's say, for instance, we have a special needs trust, and we've written in all these restrictive provisions about the distributions, and let's say grandma wins the Powerball, and now she's going to put $200 million into this trust, just throwing out numbers.
Okay.
It might make sense, actually probably would make sense, to allow the trustee to give that person as much money as needed, because if that person could get insurance that might provide different or better treatments than what they're getting on Medicaid, then it makes sense. Let's use this millions of dollars to fund the Cadillac of insurance for whatever that person needs. So that's one example I could think of off the top of my head.
Yeah, I love that. Thinking ahead. All right. Well, when are we going to terminate a trust? Let's talk about that, or what can terminate it.
Well, normally, I mentioned earlier that with the first party special needs trust, when the beneficiary dies, we do the Medicaid payback. That is the current requirement. And any funds left over can then pass to family members.
Okay.
So that's normally when we're dealing with the trust terminating. Now, as we just talked about in the last slide, that was a great lead into this. Things you'd want to put in the document that would allow the trust to terminate, because remember, it's an irrevocable trust. It cannot terminate other than when the document says.
Okay.
So if it's only at death, that makes no sense. One is law changes. We just talked about that. And that's the term I use too. I call them backstops. So the language I put in allows situations to change, or the trust to terminate, or distributions to be given for different reasons than listed if there's a change in the law, Two, I have never had this happen, but I mean, it's a lovely thought that the beneficiary recovers and is no longer receiving the means tested benefits they were receiving. Then there's no point in having the special needs trust in place in that situation either. Probably not. So allowing it to terminate if someone no longer has the disability that was the cause of receiving the benefits, that makes sense. And number three goes along with that. You're going to have a medical determination that that person has recovered sufficiently that they're not going to need these benefits anymore. I mean, mom or dad or brother or sister or trustee can't wake up one day and say, I think this person's good. You have to have a medical determination
Right.
that that person is in fact recovered and not going to need the benefits. And also court approval. I have had to go to court several times to get a trust terminated because there was not permissive language in the document to do so.
Oh, okay.
But the particular circumstances, it was in the beneficiary's best interest. So then you have to go to court, and that's expensive. And even I don't think that's fun. So I just try to draft good documents that keep us out of court.
Yeah, because you do litigation, but litigation's not fun for anyone.
No, it's not.
All right, so we're back to this. Everyone's watched this now. This is your time. Frankie, really explain why you're the person to go to with special needs, or at least why it's important to go to someone who really understands this. Because we don't want people watching this and then just calling someone in the phone book and being like, I saw this webinar. Let's talk about the importance here. Going to someone who knows what they're doing.
Well, you know, I would like to think that most attorneys who know they don't do this work won't do this work. But I hate to tell you that that's not the case.
Mm-hmm.
And sometimes it's not out of any ill intent. They just don't know what they don't know. They don't understand the ins and outs and the damage that can be caused if you don't draft these documents to comply with the federal law. Mm-hmm. So whether you're using me or someone else, another attorney that maybe you live in Wheeling and you want an attorney in that area, you need to specifically ask that lawyer, do you draft special needs trust as part of your practice? Because you are correct, Tabitha. There are very few of us that do it as our specialty, our niche, whatever you want to call it. This law firm is one, yes.
And I just want to say that's how you and I met, right?
That is true, yes.
Yeah. So there are several attorneys that I work with, and over the years, I have brought them cases and they immediately say, I am not the person for this. You need to see Frankie. Frankie's the expert. And finally, I'm like, Frankie, we got to meet. Everyone keeps referring you. We have to know each other at some point. So wonderful.
Well, I'm fortunate in that I have over the years made a lot of very valuable partnerships, and you are one of those. So
I appreciate that.
And I enjoy referring people to you as well.
Well, thank you. Thank you so much. I think it's important for good people to network with good people.
Yes.
Yeah. Why focus on the bad people when we can just uplift the good people? So, and you're the good people. I love you, Frankie. Thank you so much for doing this.
Right back at you, lady. Anytime.
All right. So anyone that's watching, if you want to get a hold of Frankie, her phone number is on here. I can't recommend her enough to help you on this topic. So you guys have a good day. Thank you. And I'll see you soon.
Bye. Yes, thank you. Bye-bye.